Act request. This is the first time in my 2 years on the board that we sat out here as a board and held this kind of conversation, and that there has been this kind of appeal to the Board of Education. The reason this appeal comes to the Board of Education truly is around some questions about whether or not, and there'll be a few questions that we're answering in here today, but some concerns around Mr. Rolen's part in responding to this, and some questions about the release of those confidential documents or what those confidential documents are. So the board's been asked, and normally we don't necessarily just step in and intervene, but given that our general counsel is actually one of those where the discussion has been around, is there a possible conflict of interest? There's no guilt stated at this time, but the question is that, so that this has come before the board to be more of the judge than general counsel who normally would respond. So what I wanted to start out with, since this meeting is really held to address the district's handling of the Public Records Act request, I think it's good to start out with really asking, and again, this Public Records Act request went to Dr. Lawrence and Mr. Rolen, both. It did not come to the Board of Education. It went to those two individuals. And Mr. Rolen was the one that responded. But what I want to go back through is just asking a few questions of staff here, and it'll be Mr. Rolen and Dr. Lawrence. And I'm not sure, as the board has not talked about, you know, what it is, how we will proceed in this. I simply drafted questions that are an attempt to get us to articulate and to review what our policy is and what our response was, because we're being asked to look at whether this was a proper response. And so in order to understand if this is a proper response, what I wanted to start with, and what I posted on the agenda, is to look at our Public Records Act request. So I would ask Mr. Rolen and Dr. Lawrence, just in a few minutes, not a long treatise on this, but when a Public Records Act request is submitted, what's the district's practice in responding to it?
I'll respond to that, Ms. Hanson. Thank you for the opportunity. I want to take this opportunity to clarify any misperceptions about our response to Public Records Act requests. To those members of the public who did not attend our Public Records Act request study session on the 23rd, I apologize that some of this may be somewhat repetitive. But, and also Mr. Borenstein's letter, I found out, was posted on the district's website, and I do have, for public review, the response that we did, though, so the entire matter's in context, his response to my response. So that is available for public review. Just generally, we receive approximately, conservatively, one Public Records Act request a week in this district. That requires staff to collect, to locate, to search out these documents because the Act so requires. Unfortunately, it's an unfunded mandate. It permeates all levels of our organization. These requests go from every level to the board, to the superintendent, to assistant superintendents, to directors and principals, and so forth. So we take a tremendous amount of staff time and effort and energy to comply with the Public Records Act, as we must. But it is an unfunded mandate, so every time we spend time complying with the Public Records Act request, again, which is very important, we divert time from our essential mission, which is educating students, and what the taxpayers pay us to do. So I submitted to the board some time ago some information that demonstrates that the legislature is actually looking at allowing us to recover mandated costs for our response to Public Records Act requests, much like we do in our labor negotiations. That would require us keeping a record of every person who responds to the request, how much time they spent, giving a complete accounting to the state, and perhaps sometime down the road we could get a portion of that reimbursed, but as of yet we have not received any money for that. So I just wanted to clear up that, but that we don't have a process in place for that either. Okay, we have not done that yet. With regard to our processes and the Act itself, the Public Records Act does not say that any person at any time can request any record and they can get it immediately. That's not what the Act says. The legislature engaged in a 15-year debate to come up with a law that recognizes, appreciates, and honors the public's need to receive public information. And at the same time recognizes that there are certain circumstances that the public's receipt of a document or disclosure of a document is not in the public's interest. So these situations are essentially privacy rights and the a government agency's need to perform its business efficiently. There are, I would say, somewhere around 40 exceptions to the Public Records Act request where documents should not be produced. So in light of that, it's a very legalistic procedure. And since it's a legalistic procedure, these requests come through my office. When we get a request, we calendar it for the 10 days, we review it, and we send out an email to all appropriate staff members to collect the universe of the documents. Again, we calendar it for 10 days because that's the response time set forth in the statute. There's been some concern that we don't respond promptly. Let me allay those concerns. The Act provides for a 10-day response time, but also there are circumstances that the Act allows the agency an additional 14 days, so 24 days, to respond to requests of a specific nature that are voluminous or require off-site exceptions or off-site collection. In my 8 years, we have only availed ourselves of that additional 14 days on one occasion. And that occasion, again, I provided a document that demonstrates the circumstances under which the district availed itself of an additional 14 days. So at the end of that 10-day period, the response requires that we identify who is responding, and in some cases we have to assert exceptions, exemptions, and privileges. And that's my job. I'm counsel to the board. I have an obligation to assert those privileges. It's been said that the privilege is not mine and it belongs to the board. That's correct. But in that the privilege is not mine, it's not mine to waive. So the board has to make that decision. So the law, we do on certain occasions set forth privileges and exceptions. We do not provide those documents. And the public and the law sets forth a process to review that. The law allows for negotiation and compromise on these issues. We can go back and forth and try to agree. But the law also allows for judicial review. And this is really important for the public to understand, because the judicial review of the response, the burden is on the agency. The burden is on the agency, not the requester, to demonstrate that the public interest is served in not disclosing documents. Not the agency's interest, but the public's interest. So the burden of proof is clearly on the agency. This is also important, that if somebody seeks judicial review saying that they don't like our response, they go to court, they ask the judge to look at the documents, perhaps order us to disclose the documents, review legal arguments, and even review documents in camera at times. It's up to them if they do that. If the requesting party gets anything as a result of this request, not all the documents they seek or a category of documents or just a few documents, if they get anything, they are deemed the prevailing party in this litigation. And they are entitled to recover fees that they expended in getting the documents. Now, by contrast, the agency, if somebody requests documents and the request is just wrong, if they just make a mistake or the request does not yield any documents, the agency is not allowed to recover fees, not allowed to get the costs expended in defending this challenge, unless the request is clearly frivolous. So that is to say that the requester only has to be partially right in order to get their fees, but they are not at risk of losing any money or losing their attorney's fees unless they're really, really wrong or reckless or frivolous, as the law says. So there is a very low risk to challenging a Public Records Act request. And one would think that if we were inappropriately or even incorrectly asserting exceptions, privileges, that we'd be getting a lot of legal challenges and we'd be paying a lot of attorney's fees. That's simply not the case. We haven't had a legal